Good morning. This is Shelley Brownell, and welcome to the Cornerstone Group Corner. This morning, we are going to be visiting some hot topics in employee benefits. These topics may not necessarily be new. There are a lot of new things happening out there, and we'll touch on those at the end of the presentation, but familiar yet frequent questions. So here are a few reminders, as we always give in our webinars. If you have any questions, please type those in the question box, which you can see there on the screen. We will try and address as many of those at the end of the presentation as possible. If we don't get to all of them, we'll certainly put those in a Q&A for folks. And as always, we post the webinar, recorded webinar, out on our website very shortly after today's, and so you should be able to find it there. This morning, I am also joined by Kyle Wolf, who is a broker specialist in our Cincinnati office, and Sarah Lucas, who is a broker advisor here in Cincinnati as well. Sarah?
And thanks so much, everyone, for joining us today. We have some very exciting topics, but I'd also like to invite you to our exclusive online AGB launch event. That is next Thursday, May 19th at 10 a.m. There's some very exciting stuff that we will be talking about and launching that day for all of our broker partners. So very excited about it. Great changes, and we hope to see you there. Thanks, Shelley.
Okay, and just a refresher on some of our other programs that we have going here at Cornerstone, our agency services program. We want to meet you where you are in your business and be that one-stop shop, if you will. So if you are not someone who is in the individual or the Medicare markets, but have clientele, folks aging out of groups, et cetera, you can refer those over to us and we will partner with you on that. Perhaps you do not have a succession plan in place. What happens to you in the event of death or disability? We have a program that can take care of your loved ones or business partners if that event should occur. And then as you prepare to retire, if you're close to that age, we certainly have programs available as well for us to assist you with that transition in life. So now, without further ado, I'm going to turn it over to Kyle and get us started.
Good morning, everyone. I'm Kyle Wolf, and let's start on the agenda today. These are based on some very frequently asked questions, and we will go over each topic to give a general understanding of what each item is and some issues that arise. So starting off would be state continuation, followed up by Cobra, Medicare coordination of benefits, domestic partners, non-discrimination testing, Senate Bill 9, leave of absence, and compliance notices. So lots to get to today. So next slide, please. Starting off, we have state continuation, and is also referred to as mini Cobra, so they are synonymous. State continuation is state-based. Each state has different requirements. State continuation is for groups with 20 or less total employees. Not all products offer state continuation. Employer's responsibility to notify member of state continuation eligibility, and some products do have state continuation administration included. So again, it's really important to know that it's the employer's responsibility to notify the members of state continuation eligibility. Some of the smaller groups don't really know that that is something that they are required to do, but it certainly is. And when I said some products have state continuation administration, the first one that comes to mind is Anthem SACA via their MIWA.io portal. So actually back in February, we had Anthem in to talk about MIWA.io and talk about how that works in coordination with the MIWAs. So that webinar has been recorded and is available on our website to view, so I won't spend too much time talking about it, but I do encourage you to go back and rewatch that. Next slide, please. So I created a state continuation and Cobra grid for Ohio and Kentucky. I just finished this the other day, so it should be accurate for 2022. Basically, what we're wanting to know is state continuation available for the carrier and product, Is state continuation administered by the carrier? Is Cobra available? And is Cobra administered by the carrier? So Cobra is always going to be available because that is a federal mandate. But state continuation, as you can see, is not always offered here. And sometimes it is, and sometimes it is also administered by the carrier. So something to keep in mind. I'm sure there's going to be questions on whether the slide deck will be available to you. It certainly will be, including this grid. Next slide, please. So going over Cobra now. Cobra is a federal continuation of benefits. It is for employees who have lost their job or experiences a reduction of hours. It's for groups with 20 or more total employees. It can be offered up to 36 months. The normal time frame is 18 months, but under certain circumstances, the coverage can be extended by another 11 months for a total of 29, in case there's like a disability that happens. If a Cobra participant dies, the qualified beneficiaries can actually have Cobra for 36 months. So Cobra can be offered to employees, spouses, former spouses, and dependent children, and those are your qualified beneficiaries. Another weird quirk here is qualified beneficiaries are covered under Cobra in the event an employee goes on to Medicare. So I'll talk about that a little bit more on our Medicare slide. And then again, it is the employer's responsibility to notify employees of their right to continuation of coverage. Next slide, please. If I didn't make it clear enough already, every carrier in each state with each product handles Cobra and state continuation differently. So I made the grid, but it's also why we're here. So if you have any questions, please reach out to your broker advisor, and we'd be happy to help. Next slide, please. So Medicare. Medicare is super important when talking about coordination of benefits with group coverage. So to start off, just a couple facts about Medicare. The initial enrollment period is 7 months. So the 3 months before your birth month, then the 3 months after, for a combined 7 months. Part A is typically at no cost. Part B is $170 a month and scales upward based on income. And like I said, Medicare is super important in group coverage. Certain members can have coordination of benefits, certain carriers have coordination of benefits with certain Medicare members. So I'm thinking of the MEWAs in the state of Ohio. There's the small employer exception request form that is filled out by the member and submitted to CMS for approval. Once that's granted, it'll go back to the carrier. The carrier will accept that as Medicare being the primary carrier or the primary payer, and then the carrier would be secondary in this case. So that's something important to know and to keep in mind, especially if you have groups on the MEWAs in the state of Ohio. With that, there's also a possibility at a premium reduction for Medicare being primary. Some carriers assume members have both parts of Medicare and bill claims accordingly, even if the member is not enrolled. So in the state of Ohio, there is legislation that allows carriers to coordinate benefits, even if the Medicare benefits don't currently exist for that member. So it's very important, very, very important to know how the carriers work and to understand your groups and your Medicare age members and help them coordinate those benefits. If you enroll in Medicare Part A and or B, you can no longer contribute pre-tax dollars to your HSA. The law stipulates that to contribute to an HSA tax-free, you must not have any other coverage other than a high-deductible health plan. The month your Medicare begins, your account overseer should change your contribution to your HSA to $0 a month. However, you may continue to withdraw money from your HSA after you enroll in Medicare to help pay for medical expenses such as deductible premiums, co-payments, and co-insurances. Next slide, please. How can brokers help their Medicare age members? I think the best way to do this is with the renewal. Typically, the renewal comes in with a actively enrolled census, and typically they'll have either a birth year or a birth date or their age. So if you see anybody who's 64 or 65, that's probably a member you want to set aside and speak with about how to move forward with their coverage. Like I mentioned earlier, if you do not have Medicare Part A and B, you could still be treated as if you do, especially in the state of Ohio, if you're still currently enrolled with your carrier. So, we had a group a while back where the member didn't want to get onto Medicare because they had group coverage. There's tons of members out there who have plenty of different reasons as to why they don't want to go into Medicare, but this one did not want to go on Medicare because they had family members on their plan as well. Unfortunately, they missed their open enrollment period for Medicare Part A. They had a surgery done, and she ended up having a lot of claims that were not going to be covered by the carrier because the carrier assumed she had Medicare Part A and B when she didn't. So the member was on the hook for that. So it is especially important to make sure that we get their coordination benefits figured out. Okay, next slide, please. And I'll turn this back over to Shelley, and she's going to talk about domestic partner coverage.
Thanks, Kyle. We're going to switch gears here a bit. And as Kyle mentioned, we're reviewing some, fairly run-of-the-mill concepts, but they are things that we get so many questions on. This one can be somewhat confusing, and I think, there are a lot of factors that come into play. State law is not necessarily the driving force here with domestic partner coverage when it comes to same-sex marriage, opposite sex, domestic partner, do you meet the definition, et cetera. The carriers have, seemingly gravitated toward allowing for domestic partner coverage. There are very few instances by plan type that you cannot make the decision as an employer, and more or less it's automatically included. But in most instances, with most carriers and all the products, they allow you to make this election. It's on the employer application, as you know, and it may have different categories, opposite sex, same sex, etc. I think one of the confusing things that occurs is, and most often we see this arise because a new hire or an employee approaches their employer, asks to be covered with a domestic partner, and then it's up to that employer, as to whether, first they want to seek the answer out from you, the broker. You then call us, and we determine, based on that specific carrier, what the options are. Oftentimes this happens off-cycle. So meaning not at renewal time. I can tell you that in the 51 plus arena, we have been successful on certain exceptions in getting this added, but most often the carriers are going to request that you ask for this coverage to be added at the time of renewal on an employer requested, on their letterhead requested by the employer, submitted with that renewal. Since so many things in small group auto renewal, if this is something that your group wants to put into play because they had a question come up mid-year the previous, you'll want to get that paperwork into your broker advisor so that we can send it in with the renewal and make the carrier aware of that. However, just because the employer elects domestic partner coverage, that does not mean that the domestic partners will automatically be covered. Every carrier has their own questionnaire and or set of guidelines, if you will. They're fairly similar, but they ask the questions in a slightly different fashion, as we see them do on most applications. And so they have to meet requirements in order to be eligible for coverage. And some of those requirements or examples of that are, is their name jointly on some utility bills? Is it on a joint checking account? Is it on rent payments, etc.? So there is proof required. We highly recommend, if your groups have domestic partner coverage, they've elected that, you're moving to a new carrier. If there are any folks that are desiring to cover their partner, you're going to want to send in those questionnaires with the new business paperwork to our team here in Cincinnati, so that all of that can be put in at the same time with the carrier, and therefore not delaying any enrollment or eligibility for those partners. But very important that if you have this situation arise, reach out to your broker advisor, and they're going to direct you on what that particular carrier's rules are and what their form looks like. As Sarah mentioned, we're launching our AGB portal. It's going to be a digital landscape for you, and we will make these forms available to you and talk more about that in our launch next week. The next one is a biggie. Non-discrimination testing. I think we enter into conversations about this, at least a few times a month. So this has to do with your employer comes to you as their broker and they say, we'd really like to give more to Joe and Jill for their benefits versus the rest of the employees, and can we do that? So you come back to your broker advisor or to a director in your market and you say, can they do this? And, first and foremost, the majority, if not 99.9% of our groups are all offering benefits with a Section 125 in place. And if they're not, they should. And we feel pretty strongly about that. This is the section of the IRS code that allows for pre-taxation of benefits taken out of payroll for the employee contributions, and there are a few different kinds. You know this as cafeteria plan, pop plan, simple, cafeteria plans, etc. There are a few varieties, and it's important that this section of the IRS code is what really makes non-discrimination testing relevant in any size group. And there are 3 specific tests, which you may not be aware of, that are part of the non-discrimination testing: the eligibility, benefits and contribution test, and key employee concentration test. And so eligibility means the plan cannot discriminate in favor of highly compensated individuals as eligibility to participate. We know there are virtually no carriers that ebbs and flows a small amount due to some of the level funded products out there to allow for a management carve out. This typically is not prevalent in our small group arena anymore at this point in time. So you can't just base your benefits and only give them to the highly compensated. Benefits and contributions. The plan may not discriminate in favor of highly compensated participants as to benefits and contributions. That's back to that original kind of scenario I threw out there. So can I give all of my managers or my top executives more money for their benefits than I do everybody else? It's a tough hiring market out there right now. We know employers are struggling. So what can they do to help themselves in this arena if they're trying to attract or lure and hire and or retain one of these executives? Well, we are probably always going to come back to you and say, do it in payroll, do it in payroll, do it in payroll. We realize that has other business implications, tax implications for that employer. There are discretionary bonuses. There are other ways to arrive at that take it out and don't violate or make a group fail the non-discrimination testing. Key employee concentration. The non-taxable benefits provided to key employees may not exceed 25% of the non-taxable benefits provided for all employees under the cafeteria plan. So that's a big math problem, right? And so if any of these tests fail, you risk that those highly compensated employees will no longer receive the tax benefit of what they contribute for their premiums, and so that's pretty defeating. That may be, certainly something that they need to have happen for their own personal tax situations, and they want to be treated the same as every other employee, right? And have that tax favorability of their premium contributions. So I would, if you run into a situation, you're going to call us up and say, do you think this violates? We at Cornerstone, the carriers, and the majority of the third-party administrators out there do not perform non-discrimination testing. If they do at the third-party administrator level, they're going to do that for a fee. So they are going to charge you, or there are attorneys out there that do this. it is not an inexpensive task. So we certainly see groups doing it. Technically, the non-discrimination testing should happen on the last day of the plan year. So you don't want to avoid it and get down to the end and go, oh my gosh, I think we may be in trouble with your groups. Some brokers, certainly employers, may not realize as well that self-funded plans as well as health reimbursement accounts also have portions of the non-discrimination testing within their plan type. So there are some unique things there. So if your employer approaches you and asks this question, certainly reach out to us here at Cornerstone. We're going to do our best to walk and talk through that. But we certainly also will say in the end, depending upon how technical the situation is, the type of employer that you have, are they an S Corp? Are they a nonprofit? Are they a LLC? Are they, incorporated? All of those different things, you may want to defer and say, you really should ask your own company attorney. Here's some broad general guidance I can give you as your broker, and or your accountant might be able to help you with this. So we do recommend, and we'll fall back on that. Not that we're not, trying to assist with the situation, but we do not perform the non-discrimination testing or the math problem, if you will. Okay, moving along, but something, kind of unrelated, but relatively new, and we're starting to get questions on this as we're coming around to the first renewal cycle for those 51 plus groups. Senate Bill 9, passed in Ohio, started on July 1 of 2021. You should know that there are similar bills that have passed in Kentucky and Indiana that also entitle a 51 plus group to this information. There are various things that the carriers have created. Some have Q&As, some have forms, some have specific ways in which they want you to request these reports, and we can help you sort that all out depending upon who your group is with. One thing is definite via the law, and there is no carrier that is making an exception for this. Reports are available one time in the 12-month experience period. So it becomes somewhat of a strategic move for you, the broker, as to when you want to request this. It might be shortly before the renewal, especially if you're with a carrier that doesn't give a large reporting package with those 51 plus groups. So you really have no way to know exactly what's going on from a claim perspective. You must have 51 employees enrolled on average in that plan, or they will not provide this report to you. So if you are on one of those over-unders that we know about out there, they are not going to provide this report to you. If you have 35 enrolled, you will not be entitled to the information. The claims are typically reported on an incurred basis. So that means it is not a true paid claim versus premium. There is an incurred factor in there, which is an estimation on the carrier's part of claims that are already in and have occurred, but have not been paid for or made it through the claims process. So there is an estimation factor in there. And so, some things that we want to, caution you when you are discussing these with a group. Certainly it gives a view, it gives more information than what these groups may have previously been entitled to. However, you don't want to rest 100% on the details in this report, and lead your client to believe, if things look relatively positive on that report, that they are going to receive a very low, or perhaps even a 0% increase when that renewal is released. Because there are many other elements, as you know, that make up a renewal with varying weights. There is trend, there is aging, demographics, census movement, plan design, pooling, a huge part of what goes into 51 to 99 rating. So they may carry more weight than this incurred medical loss ratio. And so you want to discuss it. You want to let them know that we have some information, but we know, and we hear it every week in our renewals, small group, mid-market segment, and large group. We don't know of anything going on. We think there's absolutely nothing going on in our groups, and it's all running really, really well. And then the renewal comes, and it's a big surprise moment. So these should be used, but used wisely, I think, is our our strategic cautionary advice today. Absolutely request these. Brokers, for some carriers, as I said, can request them via email. Others require a form. Others require delivery of the information to the broker and perhaps even your client. I think we'll see some of the strict parameters that the carriers have placed on the how-to request and do I need a form and all of that jazz loosen as times go on, as time wanes on. But for right now, they're sticking to the letter of the requirements as they've interpreted them legally within their own carrier. This is a biggie. Leave of absence, especially when it comes to small group. And so I'm going to lay the stage for what is the most common question that I get involved in. And it's a broker advisor comes and says, ooh, just got a call from this broker, and they've just found out from the employer that they have someone who's very ill. They've been off work, and they've been off work for 12 weeks, 6 months, my least favorite, a year, and they're still on the benefits, and they want them off now, and they need to know what they should do. So that may sound familiar to some of you on the phone. I know it'll sound familiar to some of our broker advisors listening in today. And, I think employers, especially the smaller that they are, or even mid-sized employers, they are generally benevolent. They know their employees. It could be a key employee. And certainly when someone is very, very ill, they don't want to kind of hurt them while they're down. They know they very much need their benefits, but they don't know what to do, and they don't have, any experience with it. So the first things out of the gate, so this slide becomes important because these are the 4 or 5 questions I'm going to ask immediately. So when was their last day worked? Did they stop paying on that day? Have they had any experience with this? Any past precedents and how they handled it? Do they have a handbook? Probably not. Any other kind of stated leave policy? What's the employer looking to do? What is it that they really, really want to do? Is work comp involved, which further complicates matters, et cetera? And there's a work comp claim on the bubble as to whether it's going to be approved or not be approved. Is this group by way of a control group or its own size subject to Family Medical Leave Act, which is a 50-plus rule? That will be another guide rail that we would have to take into consideration. I've pointed out the problem and all of the things that you need to find out about the problem, but what do we say to people? Each situation is going to be extremely unique. They're difficult. It usually comes, like I said, when an employer is like, oh my gosh, I thought they were going to turn to work and now they're not, and it just keeps going, and now they have this issue and this issue and this issue. So with careful discussion and consideration, a rule of thumb might be that you take that 12-week family medical leave, and that might be the amount of time that they're going to start allowing for people to be off on an unpaid medical leave, being left on the insurance, etc. The complications come in when it comes to, circling back around to the beginning of Kyle's part of the presentation, state continuation, Medicare, etc. Some of the questions are going to be, when is the last day worked, and how did this all work, and God forbid someone have a terminal illness, and now we have a life claim to complicate it. So, if someone's already blown over the 12 weeks, and you don't know what to do, we certainly are going to always highly recommend that you also take from our mouth and transfer it right over to your clients. You really want to talk to your own personal attorney about this. We definitely have an attorney on retainer here at Cornerstone. We have these conversations with them all the time. These are his most favorite questions that he lays out immediately for us, but you don't want to make any hasty decisions, that's for sure, as far as termination. And then we're certainly not trying to advise employer groups to lie about when the last day was worked. And these become very, very problematic. So as soon as they bubble up, you're going to want to reach out to your broker advisor so we can have a conversation about all of that, and know that we have some general legal advice we can obtain for you. If you're interested in a formal letter, a written opinion, any of those things, certainly, we can also assist you with that, but there would be a fee associated with that. So, this usually happens when there is no disability coverage, folks. So there's nothing to roll over into. Obviously, those things would also play a part. But they're very, very complicated. So I see lots of questions coming in. We'll get to those in a minute regarding the leave of absence. So now, last but certainly not least, want to just go over some of the required compliance notices. And, there still seems to be, gray areas, brokers who just don't know. Certainly employers don't know this. Who's policing it is always the question we get asked. But we want you, just to set the facts straight. Regardless of group size, a summary plan document is a required thing for any and all groups. It should be distributed to employees. There are rules about whether you're doing this digitally with the high-tech law, but everyone is entitled to a summary plan document. The most popular is a wrap document, because all of our plans are small in nature. So this is the one-stop place that you give information, an employer gives information to their employees about where all the coverages are, what the addresses of those coverages are, how they could get in touch with their carrier if they don't have an ID card, who's the administrator of the plan, meaning who at the employer's office should they call in the event that they have any question about any benefits offered by said employer. Summaries of benefits and coverage. Every open enrollment, these are required to be distributed. We have a lot of guides that give you information about how to pull these down from the carriers. Some of the MIWAs have these posted out on the chamber websites. There are a variety of different places. Our new portal is going to give you access to some of this information as well. Hipaa Portability notice at time of enrollment and benefits. You are to give Hipaa Portability, Hipaa privacy notices. You'll see farther down the list. A lot of times the carriers are sending those out, any and all vendors. A good idea that this also be, and a lot of these notices, folks, may be given out annually. Summary plan documents are only really required to be updated when there are changes and or every 5 years. If someone is fortunate enough to stay with their same carriers and have all the same plan designs for that period of time, unlikely in small group, but some of these notices you can put up in that summary plan document if they're not required to be given out annually. CHIP notices for all of the states. The document includes how it works for every state, where to get in touch to get that child's insurance. Women's health care rights notices to be given out annually. Medicare Part D coverage notices. We know that we do that in the fall when everything else is kicking up and we have a lot going on, October 15th of each year. And last, but certainly not least, broker commission disclosure. The new document required this year, probably starting with your February 1 renewals. Most of you wrapped up your 1/1 renewals by December 27th, which was kind of a pivotal date in the law as it was released. So that if you got everything wrapped up, you didn't have to do it for 1/1, but you need to be doing it from that point forward. We still have a lot of brokers within our Cornerstone family say that they're not really doing this yet and they're not paying attention to it. That is not our recommendation. We recommend that you certainly begin doing this. There are other annual notices that kick in, GINA, high tech I mentioned, etc. Things that newborn mothers, and things of that package nature. And we have a great solution for you. It is called EB3. We have a lot of information on our website. We've had it on webinars. We've talked about it. It's a booklet, digital booklet construction site, if you will, that has wrap documents, Section 125, annual notices, all the information that you need. If you want to find out more about that, you certainly can reach out to your broker advisor. And the most common question we get asked, but who's even paying attention to all of this? Who's watching? Well, folks, the Department of Labor does audit, and they've audited 8 life insurance agencies. They've audited 50 life, or 70 life attorney firms, and the common denominator is that everybody didn't know what to do when they got served with that audit paper, perhaps including you, the broker. We have had experience with that. We're here to help you walk through that, but the Department of Labor absolutely has every single one of these items and many more on their 4-page list of, please prepare for me. I will be in your office on X date, and I need to see every single one of these documents. We will also post, not as a, to scare everyone or a scare tactic, but there is a great little document I came across recently in my reading that shows the penalties for failure to do and to give employees any one of these documents. They are hefty, folks. And so we will make that available to everybody. We know there is sometimes a cost associated with producing these documents. And for the right groups, you may want to consider paying for that for your clients. But certainly you just need to make your employers aware that it's really important that they stay compliant. And this is one of the easiest ways that they can achieve, kind of group healthiness and compliance, and offer the right benefit package, or offer all the documents necessary. So with that, we know this is not all inclusive. There's surprise billing, there's transparency that's hitting the streets, sort of. It got delayed to July 1. Lots of folks are not planning on being compliant. The penalties are not significant enough, and all of those things. So I do think we'll have some future Hot Topics webinars coming up, and we'd love to hear from you on what are those topics that you still really struggle with. You think you get asked often by your clients, and you're really just not sure how to answer those. We mentioned several times, broker advisors, directors, always available to answer your questions. So if there are any questions in the chat box, Sarah's going to help me read those. I'm a little dysfunctional. I can never seem to get that to open up wide enough on my screen. But if they're very specific and group designed, we're going to ask that you reach out to your broker advisor, and she'll just skip over those. Okay, Sarah, take it away.
Thanks, Shelley. So a very good question first here regarding state continuation. So is state continuation allowed for both involuntary and voluntary terminations in Ohio and Kentucky? So it's very important, like Kyle said, to make sure that you pay attention to the state because each state has different requirements. So for Kentucky, they do allow involuntary and voluntary terminations to stay on the state continuation. However, in Ohio, it does not. So you have to be very aware of where your group is domiciled. So good question there. Another question is, what is the maximum period for a former employee who has to sign up for Cobra? Shelley, you want to take that one?
So Sarah, what is the maximum amount of time that they have? Is that what their question is?
Correct, to sign up, and then is the employer responsible to required to do anything to make sure they don't get in trouble?
Yes, so very good question. So as it relates to Cobra, there are definite date parameters that occur. So always important when you have those sticky situations that someone is termed appropriately, and then if a group is self-administering, a broker's administering it for them, or if you hire an administrator, technically there are 14 days that employer has to get the notification out to the employee. They have 60 days to elect Cobra coverage. And so they could at any time, retroactive to the day following the date of their termination, pay for and elect Cobra up to that period of time.
Perfect. Thank you, Shelley. And then when does the clock start for dependents to be eligible for Cobra, and for how long once an employee turns 65?
So making some assumptions there. I'm not sure if you're talking about an age 26 person. So let's say they're a dependent child. Was the question specific to children or just dependents in general?
Yeah, I think it's more asking like for six, and there's a couple questions surrounding this topic. So if someone turns
Right.
65, how long can the dependent stay on, and what are the requirements for that?
So I think, the first place to start out is if someone turns 65 and they are actively at work, they can stay on the plan for as long as they want. However, if it's under 20, important that they're enrolling in Part A and B, which, may make it less, attractive from an expense perspective to stay covered in both arenas, if you will. But the 65-year-old doesn't automatically come off the plan. If you move that Medicare eligible individual off the plan, those dependents have the same time frame to come onto the plan. They're going to receive the notifications. They're going to have the opportunity to enroll, same amount of time. There are different things, triggers that could give different or new eligibility periods of time while someone is already on Cobra. We have a great sheet that gives all the parameters of Cobra and the tips and the rules and the dates and all of that. And we will definitely make that available to everybody. And you'll hear next week how you can easily find that guide. I don't know if I totally answered everybody's question there. A lot of assumptions I think that we're making on. But an age 26
Right.
person aging off a parent's plan, again, same rules would apply there on their eligibility for Cobra if it's a Cobra eligible group.
Thank you, Shelley. A question about 125 plans. So who covers the cost, and nonprofits, are they allowed to have these plans?
So a Section 125 is really, a legal document, and there are some brokers that we have that do have their employees. They really follow the letter of the law, if you will, and there are forms that you can annually have your employees sign, validating or verifying that they are giving authorization to their employer to deduct X for benefits, X dollar amount, and they use that as almost part of their, benefit election sheet or open enrollment process. So, there is, the cost to get a Section 125 document if you don't have access to that. It varies. We have some third-party administrators that we certainly recommend, and you can visit with your broker advisor on that, and they're all going to have varying levels of cost because they've had attorneys produce those documents, update those documents, et cetera. So it's just really a one-time expense in the event that someone isn't making a lot of changes to that document. They're fairly boilerplate. So there is no expense other than that. I think that may be what you're asking. And it could be, $200 to $400, I'm going to say, in that range. Depending upon the TPA, it could be more expensive than that. And as far as the nonprofits on the Section 125, as long as it's a W-2 employee, I'm going to do some reading on that just to make sure I'm not answering that incorrectly, but I do not believe they are prohibited from offering a Section 125 plan.
Thank you, Shelley. And then we'll let Gary ask that question, so we'll let Gary know once we have confirmation on that. And then
Okay.
We've gotten a couple questions about the commission disclosures. So I'll go ahead and state that we do have some really good info on those commission disclosures or transparency disclosure agreements, we have some templates that we can share with you, as well as some additional reading material that we can share as well. So we can get that out to everyone, and that is also located on our blog. We have a nice piece on that as well. But I think that answers everything in the queue here. If we did not cover your question, and if it's kind of a specific question, please reach out to your broker advisor, and we can get to that as well. So thank you so much for your attendance today. Shelley, do you have any closing remarks?
Nope, that is great. Again, we'd love to hear what other topics, kind of hot topics that you still have a lot of questions on. And we really, really encourage you to tune in next Thursday on the 19th, because what we're launching is going to be just a great resource for our broker partners. And we're really, really excited to bring that to you. We have a team of folks who've been working very, very hard on that. So we wish you a great weekend, and thanks for tuning in today, and we'll talk to you again next week. Take care.
Sounds good. Thanks, Shelley. Bye.
Thank you.